All right, good afternoon, everyone. My name is Karen Drake. I'm a faculty member here at Osgoode Hall Law School, and it's my pleasure to be your moderator for our final panel today. This is the panel on legal education. So I'm going to briefly introduce our panelists, and I do commend you to take a look at their longer bios and the materials. I'm just going to give you a brief snapshot of their bios. So first we have Cattani Perroni, and Theus is an education specialist at Educaloy, a nonprofit organization dedicated to public legal education and information in Quebec, Canada. At Educaloy, she creates and enhances legal education tools for Quebec's English-speaking communities with a focus on the role of non-legal professionals in supporting the development of effective public legal education initiatives. Next, we'll have Professor Antonio Coronado, who uses pronouns they, them, el, and is a professor of practice and community legal education lead at Innovation for Justice, which is a social justice legal innovation lab jointly housed by the University of Arizona James E. Rogers College of Law and the University of Utah David Eckley School of Business. Here, they support the lab's efforts to train and certify community-based justice workers in Arizona and Utah. Okay, and then finally, we're going to have Dr. Ricardo Lillo. So Dr. Ricardo Lillo is a full-time faculty member at the Law School of Universidad Adolfo Ibáñez, where he is also the director of the People-Centered Justice Lab. His main areas of research are litigation law, judicial reforms, and the function of the justice system, with a recent focus on issues related to access to civil justice, due process, and the use of information and communication technologies in justice systems. Okay, so I'll turn it over first to you, Theus. Please join me in welcoming our first speaker.
All right, so hello everyone. So my name is Cattani Perroni, and I am an education specialist at the Educaloy, a public legal education organization based in Montreal, Canada. And in my presentation, I'll be sharing some insights from our project Partir et se reconstruire, so living and rebuilding in English. And this project is funded by the McMahon Fund. All right. So this project's main initiative consists of a series of legal information workshops for immigrant women who may consider or are already considering breaking up with or divorcing their partners. These workshops inform participants about the immediate and long-term legal consequences of a breakup or a divorce and are meant to be facilitated by frontline community workers who do not necessarily have a legal background. So why this project? Well, immigrant women may face greater barriers related to access to justice compared to the general population due to potential language barriers, lack of knowledge about the legal system, and a limited support network. So when it comes to breakups and divorces, more barriers add up for these women. And they might fear the consequences of separation. They might not have the resources necessary to do so. And they might not even know their rights related to the situation. So given this context, many women don't even start the process for filing for divorce or separation. So Educaloy decided to create a comprehensive project with the goal of providing immigrant women with the tools and information necessary to make an informed decision should they decide to leave their partners. But why are we partnering up with frontline workers? Well, in a context of limited support and financial difficulties, immigrant women are likely to seek support from people they already know, such as frontline workers at a local community organization who perhaps are already helping them with other issues. And because these frontline workers have a relationship of trust with their clients, they function as trusted intermediaries between their clients and the legal system that can be difficult to navigate alone. And relevant research in Canada and elsewhere have demonstrated that trusted intermediaries play a key role in improving access to justice. We've heard many times during this conference. And that's because many times they are the only help people in vulnerable situations receive when they face a legal problem. Another very important point is that these frontline workers acting as trusted intermediaries deploy a holistic approach to helping clients solve their problems. And because they have a relationship of trust with their clients, they have the opportunity for early intervention to prevent legal problems from escalating. So now that I provided a little background, I'll share a little bit more about how we developed this project. So our goal was to develop a project in which collaboration was at the center. And we planned different actions that allowed both immigrant women and trusted intermediaries to participate in the various stages of the project. So design, implementation, monitoring, and evaluation. And in summary, we partnered up with 2 community organizations. You're seeing their logos at the screen. So La Femme du Monde à Côte des Neiges et La Maison Bleue. And we've been able to complete some steps so far, and others are still in development as this is an ongoing project. And I won't go in detail over what we have done and what's in development, but you can ask me questions about it. Because I want to start talking about what I believe is the most interesting part of the presentation, that is the discussions of the insights we had from this project. So for this, I'll try to answer this question: why a partnership between a public legal education organization and trusted intermediaries can improve immigrant women's access to justice. So the first insight that we had related to this topic is that this happens because through partnership, public legal education organizations and trusted intermediaries can leverage complementary roles, expertise, and strengths. And here I have a table that illustrates this topic. For instance, in this project, trusted intermediaries had as strengths their accurate knowledge of women's needs, their relationship of trust developed with their clients, but they as limitations, they lacked legal knowledge on the topics related to separation, divorce, and they lacked the time to create educational materials on these topics. On the other hand, Educalois had the expertise in clear legal communication and legal education techniques, and the time and resources to create educational materials and information in these topics. But on the other hand, we lacked the accurate knowledge of the women's needs and the expertise on non-legal topics related to divorce that might affect immigrant women's decision to proceed with this decision. So thanks to our different expertise and complementary roles, we were able to co-create workshops that better address the women's needs. So in this project, we learned that collaboration and knowledge mobilization are a bidirectional process. It's not only Educalois that provides trusted intermediaries with reliable information, but the trusted intermediaries also share their expertise and experiential knowledge with us. And that's a key element of collaboration and a key element of the project's success so far. All right. Okay, so the second insight is that without trusted intermediaries, the project would not be adapted to the immigrant women's needs, and it wouldn't have a lasting social impact. Well, as I said, trusted intermediaries are crucial because they have a holistic understanding of the women's situation. For instance, they knew that for the clients they assist, deciding to leave is not a straightforward path. They may ask some questions one day and later change their minds, then come back again with more questions, or they are sometimes simply not ready to admit to themselves that they want to leave their partners, but would like to receive the information regardless, to later make informed decision. So some examples of key input we received from the trusted intermediaries involve presenting the topic in a way that won't scare women who are in the early processes of making a decision, and that most effectful effective, sorry. English is not my first language. And the most effective education techniques for these workshops would be the use of short activities and discussions, analysis of images, storytelling, sharing of resources and practical tips. And very importantly, that these workshops should be short and that they could be combined to other already existing activities that these intermediaries already facilitate. So here at the screen, you can see this 7 different workshops that we created. For now, they are in French, but we have the idea of translating to English as well. So yes, and on the topic of social impact, we argue that trusted intermediaries are crucial for ensuring the lasting social impact of this project, because Educala simply doesn't have the capacity to provide information directly to all women in need. So by facilitating the workshops themselves, trusted intermediaries ensure its long-term social impact even after it's formally finished. And that's why Educala is preparing a complete toolkit, including a facilitation manual and info sheets to equip these intermediaries to confidently facilitate the workshops. And in addition to that, we are also preparing informative videos on the topics, on the legal topics that are included in these workshops. So for concluding, I would like to present the takeaways. And so from our experience in this project, we argue that partnerships between public legal education organizations and trusted intermediaries can improve immigrant women's access to justice, because they allow both parts to leverage complementary roles, expertise, and strengths to better address these women's needs. And they ensure a project's long-term social impact, because trusted intermediaries can take on the project and use its materials, and so the project continues to have a social impact even after it's finished. So Educala thanks La Maison Bleue et Femmes du Monde à Côte-des-Neiges for their collaboration in this project. The project was funded by the McMahon Fund, and in general, our services in English are funded by the Department of Justice in Canada and le Secrétariat aux relations avec les Québécois d'expression anglaise. Thank you for your attention.
Testing, 1, 2. Am I coming through okay? Yep, perfect. Hello, folks. As shared, and very appreciative, a lot of this time got saved in doing the intros at the beginning, but as shared, Antonio Coronado, I'm a community legal education lead at Innovation for Justice. And we're gonna just dive right on in. I've been informed we have a little bit more time than the other panels, so get ready, buckle up. It's an interactive session. It's a bit of a workshop. This is normally an hour. I'm doing it in 15. Let's do it. So what are we talking about today? So I'm going to start with a bit of a grounding, how I come to this discussion and space. I'm going to talk about Innovation for Justice and the work that we do. There are 2 activities where I will need y'all's participation to move forward, about missing doctrinal values in dominant normative legal education in your respective jurisdiction. We're going to talk a little bit about my work to build the community law school, and we're going to close out by visualizing the many futures of the law school. Sound good? Cool. So let's start with some naming. I want to talk a little bit about how I come to this convo and what brings me to the work of reimagining legal pedagogy. So first and foremost, for me, this is a practice of resistance. So this picture here, boombox and all, I come to this work as a former law student organizer. So across law school, and I very much blame my organization for dragging me tooth and nail into the law. I did not start in the law or thinking that I wanted to go into the law. I started doing Know Your Rights work. I connected with the folks at Innovation for Justice in my pre-law life at this point. I was doing academic skills tutoring and community building. And it spiraled one way into another to say, hey, you should probably go to law school if you want to keep doing the work you're doing. Went to law school, and as a law student organizer and as someone with academia and academic skills tutoring top of mind, it was very clear we were not training folks the way that we know people learn in the world, but I will say the US context especially. So this photo is a convening of 200 of my classmates where we drafted and served the law school with a mock complaint for pedagogical negligence, for, for the unjust enrichment of our white classmates at the unjust impoverishment of the Black, Indigenous, and people of color students at our school. That, as so many folks, not just in the US, but across critical legal traditions have noted for decades, not centuries, there is an inherent dynamic whereby we don't teach history, especially in the US legal context. History is not central to the teaching of the law. The failings of the law are not central to the law. And we can unpack that in a separate presentation. But for me, a practice of resistance drives how I come to this conversation. I'm going to be employing a little bit of lived and learned methodologies, meaning a lot of this is researched, a lot of this is practice, and a lot of this is still being dreamt up as we're building and flying. And that will make sense in a little bit. And lastly, that I come to this with the duty to dream, that I, like critical Black, Indigenous, and scholars of color before me, believe it is not enough that we talk and talk and talk, but that we do, right? That we build and we do. Okay, so enough about all of the big lofty dreaming and things and abstraction. Where am I? What am I doing? So Innovation for Justice, as shared, is a virtual social justice legal innovation lab jointly housed at the University of Arizona and University of Utah, College of Law and School of Business, respectively. And so we engage folks in systems level change making, both in the service and policy levels. And what that necessarily means for us is the support of building the community law school. So I have the immense privilege of leading a team. We are 3, small but mighty, of a community legal education suite of initiatives across Arizona and Utah, which are virtual self-paced legal empowerment courses, around 50 to 60 hours in total, that provide legal skill building to advocates already in community helping roles. I do not need to belabor this point to this audience. This is community-based justice work in 2 states, in Arizona and Utah. This manifests as 3 different initiatives in the domestic violence context in Arizona, the medical debt context in Utah, and the housing stability context in both states. So at any given point, I'm working in 3 time zones, 3 impact areas, and at this point, very proud to say, a total network of 80 participating community-based justice workers in both states. No pressure. So what does this actually look like? This is going to be familiar for folks that already have heard all of the amazing presentations about community justice work across the globe, but our advocates in particular can help with legal assistance, meaning advice at intake and form filing and negotiations. They can help with court prep, and they can also attend court to serve in a quiet advisory kind of role. They are not representatives of the clients that they serve, but they can attend the court and answer questions when asked by a presiding judicial officer. I'm flying through this because this is the fun part. So now we're getting to reflection. Now you know I'm coming to this community-based justice work. You know I'm coming to this with dreaming top of mind. Please, 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 and I will monitor the chat right over here with this laptop. Please shout out what lessons we're missing from your own legal training or your own knowledge of the law. Shout it out. Humility. Trauma-informed practice. There's one in the back. Settler colonialism. Other things. Yes. Settler colonialism. Trauma-informed advocacy. I'm the one who. Humility. Thank you. Yes. Feminism and environmental concerns. Yes. Yeah. The changeability of systems. People. We're not centered in our training. Thank y'all. There's one more, I promise. So at least I'm a visual person. So at least from my perspective, as somebody that has gone through formal legal education in the US, who actively thinks about and builds legal training and skill building for community who are probably never going to law school or don't want to go to law school or cannot go to law school because of barriers. From my perspective, US legal education and licensure predominantly falls into this bucket of doctrinal legal ed as determined by, at this point, Christopher Columbus Langdell, but also the ABA and the accrediting body. Graduation requirements that happen at the jurisdiction level, as well as contents of the bar exam, whether they opt into being a UB's, a universal bar exam state. There's variants, but we could say they fall into this big bucket of what we can call capital legal education, right? We have this other bucket of radical self-reflection, systematic intersectional forms of interrogating power, truth, reconciliation, right? Listening, not leading, community self-determination, and sovereignty that actually represent the lived experiences and realities of client communities, right? Quote unquote. That's typically the dynamic. Lawyer, law student as actor, client community as recipient, the grammars of this, right? On our best day, I will argue we're somewhere in the middle. Everyone will fight me on that, on how big that middle part is, but we're trying to be in the middle, right? That we're trying to find the overlap. So in further situating it, it's important to talk about history. That was called forward by many folks in different ways. I'm gonna focus on the US because that's where I work and that's the experience I have. But as called forward, acknowledge the overlap with other nations that have settler legal histories. We know that US law schools have a fierce history of white supremacist exclusion and regulatory capture. We know from American Bar Association notes from the 1920s that the stated aims of the bar exam were to, quote, keep pure the Anglo-Saxon race. We can think and understand of lawyering as this closed language, right? Folks in sociology grapple with this, folks in rhetoric grapple with this. And we know that the profession, as of the most recent 2023 ABA profile, was 79% white, right? So when we talk about power, and when we talk about legal power, when we talk about legal information and databases, again, separate conversation about open source databases, but I put these logos up here on purpose. We're not just talking about regulatory capture of licensure. We're talking about capture of information. We're talking about capture of legal power as an entire structure and system. My goal in bringing all of that together at Innovation for Justice is to flip it on its head. So when we talk about community legal education, we're actually talking about trust-driven training. So I'm very proud to say that the vast majority of our community-based justice workers across both states are Black, Indigenous, and people of color. They're women and gender minorities. They represent an average age of 43 years old, and multiple folks identify as LGBTQIA or Two-Spirit. That's important because that is not who the traditional law school was set up to train, right? So it's not enough that we're decoding the lessons of the law school to give to community, again, that grammar of giving information, that dynamic. But when we're breaking open the law, right, are we actually translating it? So in the theme of that and of this presentation, our curricula has required modules on procedural and racial justice, on trauma-informed advocacy, and on practicing self-care, because we recognize that as folks are entering this legal profession from community helping roles, they are going to navigate the same vicarious trauma, the same forms of indignities, and the same form of socialization that lawyers go through, right? So during training, we highlight the importance of experiential learning through weekly skill building and core observation assignments. And then after their training, we have continuing education opportunities, and we try to build a broader socialization process of what it could have been, right? So for our entire team of 3, it is a reparative project as recent law school grads ourselves to say, what could our legal education journeys have been? This is a picture of the online learning course where we train our justice workers in Arizona and Utah. This is through Desire to Learn, which is a bright space technology. I'm happy to talk about the pros and cons of that after this. We also engage in iterative pedagogical design. So our curricula has been co-designed with both subject matter, meaning formal legally trained folks, and lived experience experts, meaning folks who do not have that formal legal training, but navigate legal systems by necessity of survival. Our curricula is the outcome of decades of lived and practice experience in navigating those systems. And our community law students are asked for real-time, semi-weekly feedback on each module that they complete. Could you imagine if your law professor or legal instructor asked every single module or section, how did it go? What did you wish you'd learned? We also try to engage in the construction and implementation of new metrics for justice. So this includes identifying the legal education journey from start through service delivery. So we create individualized learning plans for each of our community-based justice workers. We have regular knowledge checks and quizzes that they complete across each module. We have weekly review sessions that our team hosts for each of them. In Arizona, they take an examination prior to being certified to deliver free legal help. We have monthly service surveys, which kind of serve as a replacement because they are not necessarily at a legal aid organization, they're at a community-based organization. This is our own form of kind of aggregating that data. What would be a client management software that they would be using instead, right? How can we collect that data and tell the story of legal help? And then we also have regular community partner meetings. So once they launch into service delivery, we're meeting with them regularly. Hey, we recognize you are not a traditional legal service organization. You're layering your legal advice or legal help on top of the work you already do. How can we help, right? How are you developing legal intake for the first time as an organization? We're here to help with every step of that. So this is a little bit of picture. I love pictures if that's not already clear. So we have the feedback survey. So just a screenshot, they completed after every module. How long did it take you to take this module? So we can actually accurately tell folks how long our trainings take. On the right, the service survey. So every month they have a calendar invite to complete their services survey to say how many clients did they help in that month? How many hours did that accord with? What were the legal outcomes? In qualitative terms, what were the successes of that story beyond order of protection being granted? You know, if you were helping a survivor, an order of protection wasn't granted, but they stayed housed, how does that, you know, misalign with their ideas of what a true success story is? Here's another picture. We've been very happy to work with some amazing law students in developing these individualized learning plans. So as I shared, every justice worker starts their training term by identifying what their skills are. So because the average age is 43 years old, these are folks who maybe it's been a while since they've been in a collegiate or university setting. They've never been in a collegiate or university setting, and or they need more help with downloading an Excel file than they do understanding the law, right? So with that, we take a step back to say it is not enough for us to throw folks at the access to justice crisis, predominantly Black, Brown, and Indigenous folks. That cannot be our solution. How do we instead build a broader culture and a practice of legal empowerment? So centering them as students and learners first, as we continue to build the bench of folks who can practice and use the law. So another screenshot of our team is sharing their timeline. So every single week we start with this little cheesy timeline I made, and we move it like 2 clicks on the PowerPoint slide, letting them know where they are in their training term. We flag for Arizona folks that they have their examination coming up and service start at the end. And so it is really building a cohort system where folks can cross-train. So we train folks in those 3 discrete areas I listed right at the top, but they're all in one room across counties and across states on purpose so that they can share across silos, so they can share across jurisdictions, and so they can build community across what are settler borders and settler systems. We give them hypotheticals. So with clinical legal education and experiential learning top of mind, we have them work through practice problems during their training course. They go into breakout rooms and chat about you know, what is coming top of mind for them, maybe even before the legal answer or the legal solution to a client's problem. And we encourage them to lean on what comes naturally to them first, which is being in service of and being in community with others. And so with this last minute, I'm wondering if folks can shout out, what might the future law school look like? Overwhelmingly, to me at least, it has seemed that we continue to focus, and I will speak for myself, the dominant model is open the law school to community, never what is community doing and how can our law schools improve, right? So shout out in this remaining minute, what might the future law school look like in your jurisdiction? Maybe an adjective, a word. I recognize we're at the end of the day also. Free. Love it. Informed consent. Collaborative. Pluralistic. Practical. Experiential learning. Inclusive. Okay. I'm sure we could write, again, an entire dissertation on that alone. But this is where personal and professional writing have fully merged. So I'm wearing 2 hats here. One is as the leader of our community legal education work at Innovation for Justice. The other is someone who writes a lot about abolition. So I'm very proud to say that a lot of these thoughts have now been formalized, peer-reviewed, and published in the Quarterly Journal of Speech's special issue on abolitions. And so I tease out these a little bit further to say, what does it actually look like for us to dream of demolition, and what does it actually look like for us to center legal empowerment in this work? So that's QR code. I see folks are scanning, but if interested, okay, scan. On behalf of IA2J, thank y'all. Email, link, all of it.
Okay. So good evening, everyone. Thank you so much for our host, but also for the wonderful organization of this amazing conference. This is my second time, and I am really looking forward to the third one, whatever it's going to be. So today I want to talk about the experience that Patricia Acevedo, she's our UX director, and she's a professor from the design school. And I'm a civil procedure professor at the law school at the University of Ibáñez. It's a collaborative and experiential course with students from our university aimed at addressing a real-life access to justice challenge through legal design. Let me start by saying that for us as a team, we believe that legal design, based on the use of design thinking methodology to improve the legal system, especially for and with the people it is supposed to serve, has the potential to advance several goals of the access to justice movement. To bring the expertise and knowledge from other disciplines, to solve justiciable problems, to focus the research agenda more on those who experience justiciable problems and on what they need in order to transform justice with a user-centered or people-centered approach, and to harness the potential benefits that technology could bring to the table. This is because in the context of legal design, the use of technology does not necessarily involve the implementation of very complex and costly tools. Rather, the focus is on identifying and using technology that effectively facilitates and simplifies the effective gathering of information or the use of appropriate venues to resolve legal problems. Sometimes this may involve simple and inexpensive technological tools, and sometimes it may involve more complex ones. So legal design, therefore, for us, has the potential to bring the gap between technology, individuals, and legal services. We also believe that by introducing legal design and the design thinking process into the education of future lawyers, we can provide skills and tools to agents of change to play a key role in the access to justice crisis. It is a useful mechanism for our students to learn and communicate with the persons seeking justice, professionals from other disciplines, rather than focusing them on learning to interact only with other lawyers and the law. So based on this idea, and thanks to the generous support of the Tinker Foundation, we designed our course, Legal Design and Access to Justice at our university, with the aim of providing an experiential learning opportunity for groups of students to work in an interdisciplinary way and with a project-based learning methodology to develop proposals to improve access to civil justice in our country. The projects developed by our class under the guidance of the lab team are based on real challenges brought by institutions of the justice system, and the proposed solutions are developed following the design thinking process. During the semester, law, engineering, and design students follow the design thinking phases, which include empathizing with users, defining a problem, ideating solutions, prototyping, and testing. In fact, our students get to the point of developing a low-resolution prototype in interaction with users, and our idea is to later move to a more robust testing phase as a collaboration between the lab and the client, which is a judicial institution. For example, for this project, we are currently in the phase of preparing a pilot program to test and gather evidence for future implementation in a joint effort with the Access to Justice Lab at Harvard. So our semester began with a visit from a Chilean judge from the Family Court of Osorno, which is a small and rural jurisdiction in the south of Chile, who at the time was also a member of the board of the National Association of Judges. And she gave us a presentation, and she presented the challenge, and she discussed with our students the challenge they had to face. And the thing is that prior to COVID-19, payment of alimony was not a matter of widespread concern among the Chilean population. At least you might find that in our legal needs service that was published by that time. It was during the mobility restrictions and lockdown in the context of legislative debates to allow people to withdraw certain percentages from their pension funds to meet their financial obligations and basic needs that widespread non-compliance with alimony orders became apparent. This is so because the regulation governing these withdrawals stipulated that they could not be subject to any restrictions other than those necessary to comply with alimony orders. So as soon as it entered into force, there was a rush of these precautionary measures. Thus, the pandemic showed that in Chile, there is a significant rate of non-compliance in the payment of alimony. Although this situation has multiple causes, one of the reasons that explains is that alimony debt is easily avoidable over time. Thus, for each monthly violation or non-compliance, the claimants, mostly women without legal assistance, end up giving up the support out to their child. In 2021, the Office of former President Sebastián Piñera proposed a bill to improve the enforcement of alimony orders by, among other things, creating a national registry of alimony debtors, with the aim of creating incentives to comply with the orders and improving the exchange of information among the institutions involved in the enforcement process. Since this new regulation in 2021, the number of alimony cases has increased not only in absolute terms, but also as a proportion of total family court case law. As expressed by the judge who visited our class, since the new legislation, there has been a steady increase in the number of users at the front desk of the court, and more generally, in the number of pending cases, of which child support cases represent a considerable proportion. Today, after the court's decision on the merits, both parties receive a detailed monthly statement with the payment order. This notification is sent by an automated module that is part of the court case management system. And what the parties receive is an email with very basic information, such as the details of the court, the name of the parties, the identification number of the case, and nothing else. This cryptic email is accompanied by a PDF document containing a detailed monthly statement that is so convoluted and filled with legal jargon that it's difficult for lay people, and according to the judge, even for lawyers, to understand. This results in delays as well as monthly litigation to challenge these statements, with the resultant overburdened dockets, which in turn affects the functioning of the family justice system as a whole. Therefore, the challenge of our students addressed was how to improve the notification system and this detailed statement of child support payments to the end users of justice. In order to empathize with the user's perspective, our students explored the experiences and perceptions of the users in the current pension payment system in Chile, starting with the notification of the debt statement. For this purpose, they learned how to create a semi-structured interview questionnaire for an in-depth interview with open-ended questions designed to collect information on different topics, the first of which was related to the notification of the pension document and the whole experience. In addition to the complexity of both documents, we found that payments, reminders, and updates were ineffective because they often did not reach the intended recipients. Because the collection of basic contact information was often supplied by users and manually recorded by front desk staff without proper validation, this information was outdated or simply incorrect. Naturally, this led to missed payments and other complications. In addition, interviews with end users revealed that they were unaware of the legal consequences of no payments, as well as the resources and support mechanisms available. In the ideation phase, we carried out various activities to unleash the creativity of our students. Law students were not very creative, such as brainstorming or Lego serious play, through which our students launch ideas on how they would solve the problem posed. From this stage, the prototyping phase began, in which the students brought the selected ideas to life and intervened both in the notification document and in the debt statement. Our students' intervention focused on 3 key areas. First, recognizing the importance of clear and concise communication, the team redesigned email notifications, which is you can see in the screen, and payment statements. Complex legal terminology was replaced with plain language, and key information was presented in a visually appealing and easily digestible format. Starting with the notice the parties receive, our students design a new notice to be received via mobile smartphone app or traditional email, using an iterative process that allowed them to create multiple versions of this document, trying to provide clear and concise information with links to additional information, and adding a direct payment button. Similarly, the monthly statement that accompanies the notice was redesigned to be a much more understandable and concise document. To provide immediate assistance and answer common questions, our team developed a simple plain language step-by-step guide that can be accessed directly from the notification or from the monthly statement. In addition, they designed the flow chart for an interactive chatbot to answer basic questions about the documents and payment process, which also allows for real-time tracking of how users interact with the tool. Third, the project explored integrating payment or direct deposit options directly into the reporting system, making it easier for payers to meet their obligations quickly and efficiently. These initial designs were discussed by the interviewees at least in 3 iterations in order to evaluate the prototypes based on 4 fundamental questions. What elements stand out or what they like about the prototype presented, what elements or concepts they do not understand about the prototype, what they will improve in what they see, and finally, what they do not like about what was presented both in the notification and in the payment statements. Only after that, our students designed an initial low resolution prototype of an app which provides for ID validation using the electronic signing system that every Chilean has with our ID number, the same that we use to pay taxes and for every public service. And this app also provides information and historic information of alimony payments. At the end of the semester, our students gave a final presentation in the form of an elevator pitch to an audience composed of the Supreme Court justices responsible for modernizing and implementing the new child support legislation, the dean of our law school, members of the National Association of Judges, and the staff from the Office of Technology and Judicial Administration of the Chilean judiciary. A pilot program now it's planned to test the solutions in a selected family court with the goal of scaling up the implementation if successful. For this purpose, we are planning to take the low resolution prototype to something more elaborated in collaboration with our client, which is the judiciary, and integrate this app with the case management system of the judiciary through a collaboration agreement that we're in the process of signing. This is a tough challenge since we have encountered some resistance, not from the judges, but from the administrative office of the court. Let's see how it goes. Of course, while the full impact of our project proposed solutions remain to be seen, in fact, the notification sent by the judiciary already changed to this new version. For us, notwithstanding what comes next, the course is already a success. We believe the initiative serves as a powerful example of how legal design can be used to transform the way of our lawyers are trained and to improve access to justice. Based on this experience, we are now working in a second challenge, this time brought by the Chilean Legal Aid Office, which I hope I can share with you perhaps in the next International Access to Justice Forum. Thank you so much.
We now have time for questions and discussion. So please feel free to make your way to the microphone.
So thank you guys all for the fantastic presentations. My question's both for Ricardo and Antonio. Ricardo, you mentioned that you're working with the Harvard IA2J lab, and so I'm wondering if there's, they normally do randomized controlled trials, and so I'm wondering if there's an evaluative component to what you're doing. And also, Antonio, that's the same question for Innovations for Justice. So how does the iterative design process work, and what are the methodologies that you're employing to test the tools that you're developing, or the tools for the community justice workers? And then how does that contribute to like the next year's class design?
So after we presented this idea in December, I had a meeting in March with the Chilean Supreme Court to present this idea. They were delighted. And I would say that the main point, it was they couldn't believe that we actually interview users. So, what? Really? But in the same meeting, there was people from the informatics department, and they were, no, we already changed that. We don't do anything. We're doing great. So I learned from a friend, a colleague at the university, that my university, we have a collaborative research agreement with Harvard. So I got Jim, and I asked him, hey, would you be interested in doing this? I thought having Harvard back, my Supreme Court would be much more willing to do it. So Jim was, okay, let's go for it. So we're in the process of applying to this collaborative research agreement. And we're in the process of signing an agreement with the Supreme Court to have this randomized control test in this pilot program. I hope, hopefully this year.
And then I'm going to combine a couple of answers, and I actually get to cheat because we use design thinking in our processes. So thank you for laying it all out. So before launching any of our community-based justice worker initiatives, we engage in landscape analyses and a layered participatory action research process, employing systems and design thinking. And so in collaboration with community that we the client recipient of whoever this project goes toward, we poll folks and system actors from across the state. So not just who would actually participate in these programs, but also who is in the court system that has to authorize this, right? Who are the lawyers, members of the bench and bar that have to accept this as part of their new legal profession, right? Who are the survivors and the tenants who would actually be going to these justice workers? So we flip this idea of a recipient project on its head to say we are all recipients to a broader ecosystem of change making, right? So we engage everyone in systems and design thinking through participatory action research, one. That goes through the full design and systems thinking processes. It launches as a report and recommendations. We then work with system actors in Arizona and Utah. This goes all the way back to 2019 at this point, and we're very proud to celebrate 5 years of this work, which from the panel earlier is nothing compared to 70 years of the work, to be clear, recognize. And then it launches into some kind of state level waiver, rule change that authorizes this work. Then, based on the report and recommendations, we have a skeleton for what the curriculum will look like. And so then we work with community partners to develop what are the required modules going to look like. We engage attorneys across the state in developing that content and recording it. It then is created. I train folks, they go through the curriculum, and then we pivot in a number of different ways. Real-time pivoting. Week by week, I am changing curriculum based on how many folks showed up to a training term, based on how many folks are showing up in these spaces, how they're engaging, what lands, what doesn't land. No different than I would be for formal traditional law students, right? It's the exact same service. So we pivot week by week even on the curriculum, what's landing and what's not. We pivot module by module. So as I shared on the screen, we get regular modular feedback from folks to say, this didn't work, I didn't like this layout. So then for the next module, we can adjust things as we need to. And then we also hold the entire summer to rework and re-record things. So it's an iterative process from beginning through implementation.
This was a really excellent panel, and I just want to thank you all very much. I had a question about the trusted intermediaries. I'm just curious if you could tell us a little bit more. I'm sure there's some ways that they are self-selecting or selected by their colleagues who are thinking about leaving their partner, but could you tell us more about how they sort of enter into that role and what they feel like when they're in that role, if you have information on that?
Yes, so for this project, we partnered up with two women's organizations. So actually, when we consulted everyone that would be involved in this project, it was interesting that none of them saw themselves as a trusted intermediary. But when we started discussing what that would mean, they recognized that themselves immediately. So for these two organizations, they are like social workers. La Maison Bleue is an organization that provides services for women who are from low income and refugee backgrounds that are currently pregnant, and up until the 5 year, the baby is 5 years old. So they have many types of people working there. So I'm not sure if that answers the question, but we in this case we worked with organizations that had people working there specifically. So we didn't open it to other organizations or people who self-identify as trusted intermediaries so far.
Well, I'm going to, oh, no, please go ahead.
Wonderful panel. Just a quick question for Antonio, and maybe you spoke to this and I just missed it, but do you envision, especially given your institutional home between two universities, do you envision all this amazing community justice worker pedagogy that you've developed and are constantly changing, some kind of direct sharing or collaboration with law schools, like between law school students and community justice workers, not any kind of hierarchical mentor, but some kind of exchange? Or is that part of kind of the goal eventually? Thanks.
That is a wonderful question. So as I shared earlier, we are a mighty, lean, and mean team of 3 running all this in 2 states. So it is what ever we have capacity for at this moment. We want to be very transparent to say that. Comma, and very excited to say that we launched an externship program this past summer. And so we engage law students, and I've opened it up to any student at any university, whether that's undergrad, grad, law student, to participate. We're actively working to secure funds. So we have some funds for folks that are participating, but I want it to be even more. But we engage students who are at an informal training processes through university to help build out curriculum in terms of identifying additional resources like legal dictionaries in multiple languages. They help join our weekly review sessions to answer questions. They might not have the substantive law, but they could say, yeah, actually, reading a statute is confusing. We can bond over this. Like we're having a similar disorienting experience in navigating the law together. So that is a little newer, but it is happening. So I appreciate that question.
Well, each of these presentations was so rich and inspiring. And so I'm just going to use my moderator's prerogative to ask some questions here myself. So Ricardo, as a law professor myself, I am blown away with what you were able to accomplish. You know, not only did your students have such fulfilling learning experience, but you actually solved a legal problem for the legal system and have this really tangible, concrete result to show for it. I guess I'm also extremely intimidated by how much work did it require for you to support that course, and you're going to do it again. You know, I'd love to do this too, but what resources did you need? And did you, as one instructor, pull this off, and how did you do it?
That's a good question. My kids, they miss, no. It's a lot of work, of course, but as I said, we had the generous support from the Tinker Foundation. So with the support of Tinker, we were able to basically create our lab. So, and I had a team of junior researchers and interns. And so, but we were, this course is part of our, we do research, we do a lot of stuff as well. But let me say this, in terms of the legal design and access to justice class, the most problems have been to how to plan for having continuity at the university, because our funding from the Tinker Foundation ends this December. So we had to secure the funds from our university, show them that it was important. Luckily, my dean she's awesome. And she have been able to provide us and secure the funds for the course that we're doing right now and the next ones. And also you need, I'm a lawyer. I'm a continental law trained lawyer, which means only law since 18 years old until 23 years old. I started in the US, then my doctoral program and everything, but still, so you have to team up. You have to team up. I team up with Patricia. She's a professor at science school, so she brings all that knowledge in the table. And we have other researchers who come from the engineering school, from the programming part. So that's the only way to do it. And being in a university makes it much more easier, because you just cross the next building and you're in the engineering school and you know somebody, having lunch and discuss how you can pull things up. So that'll be it.
Okay. Wonderful.
Great presentation, so interesting. Have any of you faced pushback or input or positive comments from the bar or legal associations, institutions, other than the law schools? No.
How long do we have?
Bring the beer or something.
There's time.
Okay, yeah, so I'll jump in then. Yeah, I mean, I think this came up a little bit in some of the prior panels, but I want to be super clear that the model for community-based justice work that we implement and oversee in Arizona and Utah is not a supervisory model. So we train folks and then we pair them with an attorney mentor. So they're not directly supervised by a barred attorney. It is more of a train deep and mentor model than it is a train maybe in a shorter and then supervised model. And so because of that and because of that distinction, there continues to be a lot of questions, misunderstanding, and deep concern, particularly around or in comparison to like notarios or other forms of community justice making that is exploitative, which I think there's a lot to unpack there. But I will say it's really hard to disentangle what it means to have distrust of, I will speak for the US, to have distrust of Black, Brown, and Indigenous folks learning the law, but maybe not the same level of consternation at the national level over lawyers supporting fascistic aims in the US. So that's generally my response, is like, legal power is only dangerous because our legal system is dangerous and harmful.
Either one of, yeah, the other two.
Nothing that I'm aware of in my case. Yeah.
Well, in Chile, legal representation is mandatory by statute. So if you want to file or be a defendant in a civil case, you must have a lawyer, or you don't show up at all, which is what happens in Chile most of the times. So if you have a small claim, for example, in Chile there are no small claim courts, so you need a lawyer to file a claim. And if you can't pay a lawyer, you just lump it. There is no way you can do it without a lawyer. So as you can imagine, the law professors in Chile, especially procedural law professors, are most practitioners who spend some times of the week teaching civil procedure. So there have been a lot of resistance. I remember I did some work in small Bonnie Hughes, amazing work. And I did a small concurrent empirical study in Los Angeles, and I went back to Chile and I had a meeting with the Ministry of Justice to tell him, why don't we open a small courts? And the full table, it was his and her advisors. They were all lawyers. So everyone said, we cannot do that because of the Constitution. There is something called due process. So yeah, it's been a struggle, but step by step.
Question, suggestion. Thinking mainly about the project Eagle design project, but actually I think it would apply for 3 of them. What about bringing some economists to the table for evaluating what you're doing? Because each of what you're doing has a massive impact for bringing more money in the pockets of the people who are impacted, right? And like, if you have economic students who just do the evaluation for, oh, let's show how much like child payments money we bring, both from the court perspective, but also from the user perspective, you also have a new argument to bring to the Supreme Court in the discussion. So maybe, I don't know, for next year, if you want to bring some more people, but also for the community organization or, you know, the Quebec project, like I guess there's a massive impact on the people you're helping out, right? So is that something that you have been thinking of or open for?
In our case, absolutely. And psychologists, I think it would be awesome as well. But in terms of internal bureaucracy of the university, it's not that easy to offer a class for students from different schools. There is a lot of bureaucracy involved. So,
but you got engineers, right? So
you got what?
You got engineers, right? And so legal people.
Yeah.
It's not that far.
Supportive dean of the engineering school.
Yeah, I'll quickly add, we are very fortunate and are very privileged to be working with an actuary in Utah who is helping us conduct a return on analysis, or ROI, return on investment of justice work that we're doing. So they're helping build out what it looks like to collect the right data to be able to tell that story. And so we're implementing that already in both states. So heard and yes.
Yep, for our project, I would just say that we have some people on our team that are working for collecting data and analyzing it afterwards, but I'm not completely sure about how it looks like, so I'm not commenting on this.
Okay, so Antonio, I'd love to get your thoughts on a kind of dilemma that I struggle with. So as a faculty member who is Indigenous, I'm a member of Wabeco Ojibwe Nation. One of my goals has been to, you know, quote unquote, indigenize the law school. And as the years go by, my commitment to that is really waning, honestly, because I, wonder whether the attempts to bring Indigenous laws into the law school just results in them being distorted, and whether they can be effective in that kind of colonial environment. Whether really more harm than good is happening. And so I guess I want to invite, I'm just so grateful for all the experience that you have brought here, and just invite you to, maybe comment.
Perfect, yeah.
Yeah.
I really appreciate that question, because that is not ever the question I get in these panels. It's usually like, oh, what, so thank you. I love this. And I appreciate you sharing that too. So that is, I'm going to defer entirely to the QR code that I put up about the article about abolishing the law school, because it's a both and, right? Like, we know it is building while we're flying. We know it is building while shrinking the systems that are doing harm. So I come to this with a non-reformist reform perspective that there's only so much I could do within the settler system and with the privileges and the power that I have. So what does it look like to reimagine the system that I've been dealt, while also dreaming and working in service of folks that, whether through movements of Black liberation, through Indigenous sovereignty and self-determination, through collective ways of being that folks of color practice every single day in resisting settler systems, how can that be the future? So that's why I closed out with the dreaming at the end. But very concretely, I do, both in my scholarship and in our work, talk a lot about what it looks like to apply a just transition model to the law school. So for folks that are unfamiliar in the environmental justice context, the idea of a just transition, what does it mean to shrink pollutants and destructive environmental systems and replace them with renewable or reparative even governance systems, and also ways of energy production. And so I apply that to the law school to say, okay, how do we talk about shrinking this pollutant and toxic, harmful structure of legal power and legal gatekeeping? What does it look like for us to shrink the law school as a system doing harm? What does it look like for us to shift power to those most directly impacted by the legal system, those who are primarily Black, brown, working class, and lower income, right? So I love this question because I think it's the next step of this, right? Which is like, it's not just enough to build, but what are we actively unimagining? I like to say, what are we actively decommissioning as systems to say, actually, as we're re-regulating the profession, we're deregulating the profession, right? We're getting rid of the idea of the bar exam. We're getting rid of character and fitness, and we're actually asserting everyone is worthy of legal power. It's not enough that we're loosening the restrictions. We have to rethink the entire model. So, thank you.
Okay, thank you. All right. Well, I'm not seeing more questions. And so I think that with that, I just want to thank our panelists so much. This has been such a rich and generative discussion. I've benefited so much, and I'm going to take this back to my own work and my teaching. So thank you.
Thank you. Thank you all.